Okay, let's look past the day-to-day headlines for a second, because right now, something really fundamental is happening in courtrooms all over the country. We're talking about a quiet but super intense battle over the very limits of presidential power. And, this isn't just about politics. It's a huge stress test for the rule of law itself. I mean, listen to that phrase, the last circuit breakers for the rule of law. That's powerful stuff. So let's dig into what that really means. We're going to explore how the courts are responding to some pretty bold moves from the executive branch and how they're acting as, well, a critical check on that power. All right, so to really get a handle on the reaction from the courts, we first have to look at the actions that are prompting it. I mean, what's causing judges to use language that's being described as steeped in constitutional alarm? What exactly is going on? Well, a few key patterns pop up again and again. We're talking about moves to politicize the civil service, use federal funding as a weapon, and get rid of independent officials. But to really see this dynamic in action, let's zoom in on one really high-profile case that touches on that last point, prosecuting political adversaries. Now, this indictment of James Comey, it didn't just happen out of the blue. You have to remember the context. This came after the president was publicly calling for charges, and right after a U.S. attorney, who reportedly refused to go for that indictment, resigned. So the timing is pretty interesting, to say the least. Okay, and check this out. Look at the legal teams involved. For the prosecution, you have the president's former personal defense attorney, who has zero prior experience as a prosecutor. And on the defense side, Pat Fitzgerald, a guy described as a super respected, very experienced, longtime prosecutor. I mean, that contrast in experience, it's pretty stark, and it tells you a lot about the kind of legal battle this was shaping up to be. So you might be wondering, what was this indictment even about? Well, that's where things get really fuzzy. The indictment was so vague that legal experts were basically just scratching their heads, trying to guess if it was about one old case or a completely different one. The fact that nobody could figure out the basis for the charges, that became a huge part of the story. Okay, so with that context in mind, let's pivot to the courts. How did these institutional guardrails, these circuit breakers we talked about, actually respond when they were put under this kind of pressure? Let's take a look. All right, first up, let's talk about politicizing the civil service. In San Francisco, a court had to step in to stop an order that would have led to the firing of tens of thousands of federal employees. And this wasn't just about people losing their jobs. Think about the potential impact on national security and intelligence. And the court was not subtle about it. The judge basically said, nope, not happening, and set aside the directive. What that did, in a very real way, was protect the continuity and expertise inside our most critical security agencies. It was a direct pushback. Okay, next issue, weaponizing federal funding. Here, we saw an attempt to slash over $230 million in counterterrorism funding. And the catch? The cuts were aimed specifically at states led by the opposition party. So right away, it was challenged as using security money for political payback. And you've got to hear the court's response. It was incredibly blunt. The judge didn't just stop the cuts, she called the whole justification for them slapdash. Slapdash. I mean, that's a pretty strong word from a federal judge, and it sent a crystal clear message that you can't play politics with national security funding. And finally, let's touch on the independence of our major institutions, specifically the Federal Reserve. A judge had to rule on an attempt to remove a sitting Fed governor, and you have to remember the whole point of the Fed is to be independent and walled off from day-to-day political pressure. So the whole case really boiled down to what for-cause removal actually means. The judge's ruling was super clear. It means things like actual misconduct in office. It does not mean the president just disagrees with their policies. This decision was basically the court reinforcing that firewall between politics and the nation's central bank. Okay, so why is all of this happening now? Well, it's important to understand that these court cases aren't just random, isolated events. They're really just the latest skirmishes in a much larger, century-long ideological battle over just how much power a president should have. And at the heart of this entire fight is a Supreme Court case from way back in 1935 called Humphrey's Executor. This is the landmark decision that said, hey, Congress can create independent agencies, and the president can't just fire their leaders on a whim. There has to be just cause. And for decades, this case has been a major target for those who believe in a stronger presidency. And you can really see this long-term effort playing out over time. It starts gaining modern steam with Justice Scalia's famous dissent in 1988, championing that unitary executive idea. Then, in 2020, a different case starts to weaken those protections. And now, the Supreme Court has actually agreed to hear a case that puts Humphrey's executor directly in the crosshairs. So this isn't new. It's a fight that's been building for a long, long time. So that brings us right back to where we started, doesn't it? We have a system that is clearly under an immense amount of strain. You've got these bold executive actions on one side and these incredibly sharp, forceful responses from the judiciary on the other. You know, when you piece all of these rulings together, what you're really seeing isn't just a bunch of one-off legal fights. You're seeing the judiciary as a whole reasserting itself as a co-equal branch of government. It's like they're drawing a line in the sand. And that really is the crucial takeaway for all the legal experts and national security folks who are watching this unfold. The system is definitely straining. You can see it. But for now, it's holding. But that leaves us with the big, unanswered question, right? The guardrails have held this time. But with that foundational Humphrey's executor case now up for debate at the Supreme Court, you have to wonder, just how much more strain can they really withstand?